My name is Jim Sellers. I'm a plaintiff's trial attorney who practices in Oregon, Washington, and I'm going to try and answer some questions for you that I have clients ask me. Dress if they're a woman, but if they dress plainly, simply, and attractively, that is sufficient. With respect to myself, as a plaintiff's lawyer, the one thing I try to avoid doing is wearing tailor-made shirts. Not that I have a bunch of them, but I have a few, and I don't wear those to trial. Or flashy, bright clothing. I try to wear muted, subdued colored suits like blue or black or shades of brown or gray, and then plain, unpatterned shirts. I joke that I buy my shirts that I try cases in from Land's End in their mail order catalog, and it's true. And actually I wear those shirts at other times because I'm very fond of Land's End. But nothing's high-end because I think it creates a bad impression with jurors. To give an example of the extremes that are involved with appearances, is I've represented college cheerleaders who work as doing exercise studio work and things like that after they get out of school, and I've represented a state contestant for Miss of whatever the state is, and those women are very difficult to present because they're very, very attractive. They're usually very fit, and most of the jurors are not. And I think some jurors look at them and think, "What's your problem?" So those are just psychological things that must be overcome so that the jurors are not biased against the plaintiff. In loss of consortium claims, which is loss in society and companionship of the spouse of the person who's injured, I mostly recommend not bringing those claims except in special cases, because you have a lot of elderly people on most jurors, and you have other people that whose sex lives are not great, and loss of consortium is often thought as the last loss of sexual capacity of the person who's injured because of the injuries. And so if the plaintiff and their spouse rails on about the loss of their or the diminishment of their sex life, some jurors have a hard time appreciating that because they're experiencing the same thing, and not for reasons of injury necessarily. So those are just some of the psychological factors that affect the presentation of a case to a jury. So, and then of course the final thing is this. If the plaintiff or the plaintiff's lawyer is perceived as not truthful for any reason, or is perceived to exaggerate, jurors will not like that and will hold it against the plaintiff. And so I always counsel my clients to be absolutely truthful, and what goes along with it is to be humble people rather than ostentatious, loud, brash, which are things that turn everybody off, not just jurors. So those are my thoughts on some of those things, and it was nice talking to you this afternoon. One question that my name is Jim Sellers. I'm a trial attorney. I practice in both Washington and Oregon. I represent people that are injured. One of the questions that prospective clients often ask me is, at what point should they hire an attorney? And the answer to that's pretty easy. The earliest that you can hire an attorney to represent you on an injury claim is the best. A lot of people figure they can fiddle with a claim or defer getting